Welcome to the debate. Usually when we think about a property line, there is a comforting certainty to it. You put up a physical fence.
Right, a literal boundary.
Exactly. On your side of the fence, you mow the lawn, you fix the broken steps, you manage the risks. On the neighbor's side, it is entirely their problem. It's binary, it's visible, and it's legally finite.
But health and safety law doesn't really care about your fence, does it?
Not at all. Step into the world of UK health and safety legislation, and suddenly that comforting boundary fence is completely dismantled. We're looking at a regulatory landscape today specifically governed by the Health and Safety at Work, etc. Act 1974 and the Management Regulations of 1999, where the boundary of your responsibility as an employer does not end at your payroll.
Or even at the edge of your own technical expertise, which is, well, it's the core of the issue here.
Right. I argue that these broad, encompassing duties placed on employers are absolutely vital for maintaining a comprehensive safety culture. They prevent corporations from just, outsourcing their liability.
And I maintain that the requirement for host employers to constantly oversee and verify supposedly competent third-party contractors creates a paradoxical, legally precarious, and frankly impossible burden. I mean, you are asking businesses to police expertise they simply do not possess.
Well, let's unpack that. Because to understand the sheer scale of this responsibility, we have to look directly at Section 3 of the Health and Safety at Work Act.
The big one.
Yeah, the foundational one. It mandates the duty to protect persons not in your employment. And when you combine that with Regulation 5 of the Management Regulations, which requires effective planning, organization, control, monitoring, and review, a very clear philosophy emerges.
A philosophy of ultimate liability.
A philosophy that safety is not a boundary you can outsource. You cannot just hire a contractor, point them to a hazard, and just walk away. To ensure public and workplace safety, the host employer must bear the ultimate responsibility for creating a continuous, positive safety culture.
Sure, in theory.
It has to encompass everyone on site, because frankly, a falling piece of masonry does not distinguish between a full-time employee and a visiting plumber.
Okay, but the philosophy might sound ironclad in a textbook. But this regulatory framework places an inherently contradictory expectation on businesses the moment you apply it to the real world.
How is it contradictory to ask someone to keep their site safe?
Because of what the inspectors actually demand. We see this explicitly in the inspection letters from our source material. Host employers are told they must, quote, select contractors who are competent.
Right, which is basic due diligence.
But in the very next breath, they are told they must undertake checks on the contractor's performance whilst on site to verify their competency. This forces employers into an impossible position.
I wouldn't say impossible.
It is. Think about it. A business hires a specialist precisely for tasks outside its own organizational expertise. Think about complex high-voltage electrical work or utilizing the work at height regulations 2005.
Okay, working at height is a great example.
Right. So the law demands that the non-expert host act as an omniscient safety guarantor. You remain criminally liable for constantly second-guessing the exact expertise you just paid top dollar to bring on site. It is a fundamental logical trap.
You're conflating technical micromanagement with systemic oversight, though. The law doesn't expect the host to be an expert in high-voltage wiring.
The inspection letters suggest otherwise.
No, they don't. It requires the host to maintain an overlapping field of vision regarding site management. Think of the host employer as an air traffic controller.
Oh, the air traffic controller analogy.
It works. You do not need to know how to fly a Boeing 747 to ensure the pilot is following the designated flight path, right? You make sure they are communicating with the tower, staying out of the way of other aircraft.
Right, but
Let me finish the thought. You do not need to know how to operate a specialized mobile elevating work platform to ensure the contractor is cordoned off the drop zone below, or to check that they provided their written risk assessments, or to ensure they aren't swinging heavy machinery directly above your own staff.
okay, that air traffic controller metaphor sounds incredibly reasonable in a corporate boardroom, but that is not how inspectors apply the law on the ground.
I disagree.
Well, look at the reality. If an aircraft pilot makes a specific operational error and crashes the plane, the air traffic controller is not charged for the pilot's mechanical mistake.
Because they aren't flying the plane.
Exactly. But under the Health and Safety at Work Act, if a contractor makes a technical error and falls, the host employer is routinely subjected to a criminal investigation for failing to adequately control the risks. They are blamed for the pilot's crash.
But they are investigated for their failure to manage the site matrix, not for the contractor's failure to clip a harness. If you're listening to this and you've recently hired a roofing specialist, you might be thinking, well, why am I liable if my specialist falls off the roof?
This is a very fair question.
You aren't liable for their clumsiness. You are liable if you never bothered to ask them how they planned to get up there safely in the first place.
But the line blurs entirely when you look at the mechanics of the legislation. Let's look closely at the Work at Height Regulations 2005 from our sources. Regulation 7 dictates that employers must give collective protection measures priority over personal protection measures.
Right, meaning guardrails take precedence over personal harnesses.
Furthermore, you must ensure the working surface has no gap through which a person or material could fall. So you hire a roofing specialist. They are the ones determining the collective protection methodology because they understand the structural loads.
As they should.
So if a host manager, let's say a retail branch manager, walks the site, are they genuinely qualified to evaluate if the contractor's temporary edge protection meets the statutory load-bearing requirements for a 20-meter drop?
Not the math, no.
Exactly, no. But the law says the host must verify their competency on site. How do you physically verify structural technical competency without duplicating the engineering expertise?
You verify it by checking their systems of work. You ask for the method statement they promised during the procurement phase. You ask the site foreman to walk you through the edge protection plan.
So it's an administrative check?
It's an engagement check. Because if we do not require host verification, we create a massive lethal legal loophole. We essentially legalize a fire and forget corporate strategy.
Nobody's arguing for fire and forget.
But that's what would happen. Companies could actively outsource all their most hazardous work, handling dangerous chemical substances, asbestos removal, working at heights specifically to avoid liability. They could wash their hands of it and say, well, they were an independent contractor. We assume they knew what they were doing.
But
the law forces the host to stay engaged, to ask questions, to demand proof of safety before the work begins.
Obviously, organizations shouldn't outsource danger simply to evade responsibility. But asking a host to verify the technical execution of a specialist creates a situation where the host is legally required to manage something they fundamentally do not understand. And when you are legally required to manage the unknowable, you are setting businesses up for inevitable failure.
You're completely ignoring the safety valve built right into the legislation.
Which is?
The framework does not demand the omniscience you're talking about. It demands only what is so far as is reasonably practicable. Section 2 sub 2 of the Act relies heavily on this exact phrase.
Ah, reasonably practicable. The magic words.
They are magic. This mechanism addresses your concern about impossible burdens directly. The law does not demand absolute perfection. It demands a documented, logical process of assessing hazards and mitigating them to a reasonable degree.
I'm not sure the inspectors got that memo.
Well, we see it explicitly in the source text regarding the COVID-19 risk assessments. The statutory guidance explicitly tells operators of sports or leisure facilities to do everything reasonably practicable to minimize risks, quoting directly, recognizing you cannot completely eliminate the risk of COVID-19.
That's a viral transmission, not a physical site hazard.
The principle is the same. The law is explicitly designed to be flexible. It asks the inspector to look at, quote, the nature of his activities and the size of his undertaking. A multinational construction firm is held to a different practical standard than a local corner shop hiring a plumber.
Reasonably practicable is a wonderful theoretical safety valve, I'll give you that. But I fundamentally disagree that it is flexible in practice. It is almost exclusively applied retrospectively by inspectors as a strict liability standard.
How so?
Let's examine the specific inspection letter from our source material regarding a retail branch inspection. The inspector noted that the site-specific risk assessments had not been completed correctly.
Why? Because the employees had only completed the likelihood column with a tick mark.
Right.
They had a tick mark, but they had not estimated the level of risk according to the specific assessment format. And in doing so, they quote-unquote missed a hazard, the carpet manipulator.
Which we need to clarify for the listeners is a highly dangerous piece of equipment.
It is. A carpet manipulator isn't like a pair of scissors. It is a massive, specialized piece of lifting equipment that exerts huge amounts of physical tension to stretch industrial carpets. If that mechanism slips or if the tension snaps back, it's not a minor scrape. It is a catastrophic physical injury involving severe blunt force trauma.
I'm not denying it's a dangerous physical hazard, but notice the focus of the inspector's critique here. The critique intertwines the physical hazard of the carpet manipulator with the administrative failure of ticking a box instead of calculating a mathematical risk matrix.
Because the administrative failure leads to the physical hazard.
Now, it completely turns reasonably practicable safety measures into an administrative trap. When an inspector walks into a facility, they aren't merely looking for physical safety, they are looking for formatting compliance.
That's incredibly cynical.
It's what the letter says. You can have a perfectly safe, well-organized shop floor where the manipulator is securely stored and operated safely, but if your paperwork doesn't calculate risk using their preferred methodology, you are suddenly in criminal breach of the management regulations.
Because how do they know it's safe if it isn't documented?
It prioritizes the formatting of a matrix over walking the floor and looking at the physical reality. Like in that exact same letter, they flagged a broken window in the operator's hut and a lack of drinking water under the Workplace Regulations 1992. Those are physical realities. The tick box is just paperwork.
You're separating the paperwork from the physical reality, but the legislation intentionally binds them together. A tick box is not a risk assessment. It is a clerical dismissal of a hazard.
It's an acknowledgement of it.
Putting a tick in a likelihood column without evaluating the physical consequence is direct evidence that the management team is not actually engaged with the danger. How can you legally or even morally claim you have done everything reasonably practicable to protect a worker from the lethal tension of a carpet manipulator if your formal assessment of that hazard is a single, uncalculated checkmark?
Because you've trained them on how to use it.
Here is the crucial insight. Health and safety law treats the absence of cognitive effort as a physical hazard in itself. The paperwork is the tangible proof of the cognitive process. Without it, safety is just luck. And the regulatory framework rightly refuses to rely on luck when human lives are at stake.
That assumes that the absence of a perfectly formatted document equals the presence of imminent danger. And that assumption, that logical leap, arms inspectors with tremendous, unchecked power to halt business operations based on administrative technicalities rather than immediate physical threats.
Okay, if we are going to look at enforcement powers, we have to look at how businesses actively try to use administrative technicalities to shield themselves from investigation.
Shield themselves.
Yes, I will vigorously defend the aggressive enforcement tools available to inspectors because the preservation of human life must override corporate privacy shields.
Oh, you're talking about the Nottingham incidents?
Exactly. We see a perfect example of this in the source material regarding the investigation of 2 severe accidents in Nottingham. The employer explicitly tries to hide behind the Data Protection Act to withhold information about the incidents and the individuals involved.
They were raising a standard privacy defense regarding employee records,
Which is normal HR practice.
a defense the legislation immediately neutralizes. The inspector responds by citing Section 31 of the Data Protection Act, which explicitly exempts personal data processed for the purpose of securing the health, safety, and welfare of persons at work.
Okay, fair enough. The DPA has exemptions. It strips the privacy defense entirely, preventing companies from using HR data laws as a firewall for corporate negligence. Furthermore, the inspector gives them exactly 14 days to provide the information, noting that failure to do so is a direct obstruction offense under Section 33(1)(f) of the Health and Safety at Work Act.
Heavy-handed, but okay.
This isn't a polite request, you know? It is a legal mandate. The system rightly places the investigation of physical harm above corporate data protection. You cannot legally obstruct an investigation into a workplace injury.
I accept the gravity of workplace injuries, obviously, and it is universally understood that companies should not be permitted to cover up accidents. But we must look at the mechanical balance of power in these enforcement mechanisms.
They need power to enforce the law.
Yes, but the legislation gives inspectors tools that are dangerously disproportionate. Let's draw attention to the severe procedural mechanics of a prohibition notice, which is also detailed extensively in our sources.
The emergency brake.
Right. If an inspector merely believes there is a risk of serious personal injury, they serve a prohibition notice. The employer has 21 days to appeal to an employment tribunal, but here is the critical draconian catch. If an appeal is made, the notice is not suspended.
Not unless the tribunal specifically rules in the employer's favor or the inspector themselves is satisfied that remedial measures have been taken.
Meaning the entire business operation is halted immediately without prior judicial review, and filing an appeal does not act as a stay of execution.
Because people could die.
In almost any other area of administrative or corporate law, an appeal pauses the penalty until a neutral judge can hear the facts and evaluate the evidence. Here, it is entirely guilty until proven innocent.
It's about risk mitigation, not guilt.
An inspector can walk onto a site, decide they subjectively do not like the look of how a contractor is managing a height risk or evaluating a load-bearing surface, issue a prohibition notice, and shut down a multi-million-pound project on the spot.
If it saves a life.
But even if the employer appeals the notice and eventually wins at the tribunal, proving the site was actually safe, the financial and operational destruction of being shut down for weeks or months is already done. It tips the scale entirely against the employer, creating an environment of enforcement by intimidation.
You have to look at the mechanical alternative, though. Why did legislators design it this way?
To consolidate power.
No, because if an appeal automatically suspended a prohibition notice, a reckless employer could simply file an administrative appeal to buy themselves a few extra months of profitable operation while continuing to expose workers to a lethal hazard.
You're assuming bad faith from the employers.
The emergency brake exists because gravity doesn't wait for a tribunal. The appeals process doesn't act as a stay of execution because, historically, the time it takes to process a judicial review is exactly the window of time where a fatal roof collapse happens.
But it's still disproportionate.
If we are debating a paperwork issue, an inspector issues an improvement notice, which gives you time to comply, like the 12 weeks mentioned in one of the source letters for fixing the drinking water issue. But a prohibition notice is specifically reserved for imminent risks of serious injury.
It is an emergency brake operated by a single individual whose field judgment cannot be immediately challenged in a way that allows the business to survive if the inspector's judgment is flawed. I mean, the financial ruin of an entire enterprise over a misjudged prohibition notice is a massive burden to place on a corporate entity.
See, you keep saying that, but that is exactly the misconception the 1974 Act aims to dismantle. You're talking about the burden on a nameless corporate entity, but under the legislation, corporate veils dissolve.
Ah.
We're going there.
We are. The law doesn't just target the abstract company, it targets the leadership. We need to look at Section 37 prosecutions, holding directors personally accountable under the 1974 Act. Corporate veils dissolve when we invoke Section 37, shifting the burden from nameless entities to the specific directors whose neglect fueled the offense. Well, this is definitely a critical escalation in the regulatory framework.
I always tell people, think your corporate title protects you from personal prosecution? Well, think again. Under Section 37 of the 1974 Act, the corporate veil vanishes, leaving individual directors directly in the crosshairs of the law. Today, we're breaking down how neglect and connivance can turn a company mistake into your personal legal nightmare.
It definitely shifts the burden from the corporation to the specific individuals, but proving that is another matter entirely.
Exactly. The source material speaks to this directly when it references the HSE guidance, Leading Health and Safety at Work, Leadership Actions for Directors and Board Members. What does it actually take to prove a director is personally responsible for a corporate failure? It's not just about what you did, but what you allowed to happen through silence or neglect.
And that's a very fuzzy line.
We are dissecting the rigorous evidentiary thresholds of Section 37 to show exactly how decision-makers are being held accountable. It focuses on the evidentiary threshold of consent, connivance, or neglect. It means personal accountability at the highest level.
Yes, but
Most directors believe they are shielded by a nameless entity, shielded by the boardroom door. But the 1974 Act has a powerful tool to prove them wrong. Section 37 shifts the burden of proof, ensuring that consent or connivance leads to uncompromising legal consequences. You have to stop hiding behind the boardroom door and see how the law finds you.
Right. But let's be practical. The application of neglect is somewhat straightforward, failing to act when a duty requires it. But the evidentiary threshold for connivance is what truly terrifies corporate boards.
As it should.
Proving connivance doesn't require proving that a director ordered a dangerous act. It requires proving that a director knew a significant risk existed and silently allowed it to continue. It's an inquiry into what you allowed to happen through silence.
Exactly.
But, practically speaking, this requires inspectors to essentially read the minds of directors. How else do you prove they knew about a specific failure on a vast construction site or a distant retail branch?
It doesn't require mind reading, it requires looking at resource allocation.
Paperwork again.
The evidence of connivance or neglect is found in the budgets, the board minutes, and the safety audits. If a board consistently underfunds safety training or ignores internal audits that flag the exact risks that later lead to an accident, that is neglect, that is connivance.
Right.
Section 37 ensures that decision-makers face the rigorous, uncompromising legal consequences of the act. You cannot legally structure a company to distance the board from the blood on the shop floor. The legislation ensures that the directors who profit from the enterprise share the personal criminal risk of its hazards.
I mean, look, I don't disagree that a documented positive safety culture driven from the board level down is absolutely critical. No organization and no director should be permitted to operate with a reckless disregard for human life. Where we converge is that the ultimate goal of safety is paramount.
Right.
But where we diverge and where this legislation continues to create massive friction is in the practical application of these mandates. The framework places a logically contradictory burden on host employers regarding third-party competence. It demands they hire specialists and then demands they constantly oversee and second-guess that exact specialization.
I still say that's just proper management.
It enforces this paradox through draconian mechanisms, like prohibition notices that lack immediate, balanced judicial oversight, and it prioritizes the formatting of risk matrices over the practical realities of site management.
And I maintain that those broad responsibilities, the stringent requirements for contractor oversight, and yes, the immediate, powerful enforcement mechanisms are the only proven way to ensure compliance.
By forcing fear into the boardroom.
By forcing accountability. The historical record shows that without the threat of prohibition notices, without the personal accountability of Section 37 prosecutions, and without the stringent data transparency forced by Section 33 obstruction charges, corporate entities will inevitably default to protecting their profit margins over their workers. The law says safety is everyone's problem all the time, and it gives inspectors the teeth to enforce it.
It certainly makes it everyone's legal liability all the time. I think looking closely at the specific mechanics of enforcement, how a prohibition notice actually bypasses the standard appeal stay, how a risk assessment is physically judged by an inspector on its formatting, or how Section 37 shatters the corporate veil to target individual directors, it really helps us truly understand how legislation functions in reality rather than just in theory.
Brings us right back to the boundary line we started with.
Right.
The traditional property fence might be dismantled, and the legal boundary lines might be complex and overlapping, but the fundamental obligation to protect human life remains absolute. The legislation forces an uncomfortable level of involvement because it recognizes that distance breeds negligence.
And it's up to the listeners to decide if that involvement has gone too far.
Exactly. Where the exact line of corporate and personal responsibility should ultimately be drawn is a question every organization and every individual director must answer for themselves before an inspector arrives to answer it for them. Thank you for listening to The Debate.